My name is Paul Grimm. I'm a retired United States District Judge for the District of Maryland. And for the past 3 years, it's been my great privilege to be a member of the faculty here at Duke Law School and the director of the Bolch Judicial Institute. The mission of the Bolch Judicial Institute is to promote the betterment of humankind by strengthening the rule of law, both here in our own country and abroad, by promoting and defending judicial independence and helping the public understand the role of the judiciary in preserving our founding principles. Every year, the Bolch Judicial Institute gives 2 awards to individuals or organizations that work to protect and advance the rule of law. One is the Bolch Prize for the Rule of Law, which we give in the spring. And the subject of today's program is the Raphael Lemkin Guardian of the Rule of Law Medal Award, which we award in the fall. Raphael Lemkin was one of the leading scholars of human rights in the 20th century. A Polish scholar and attorney, Lemkin dedicated his life to the study of war crimes. He advocated for the use of criminal law to defend peace and prosecute crimes against humanity. He developed both the term and the concept of genocide through his scholarly work. He came to the United States during World War II as a refugee, and he served on the Duke Law faculty before assuming duties in the United States government. In 1948, he helped secure passage of the Genocide Convention at the United Nations. Raphael Lemkin is an example of the many remarkable individuals in our history and around the world who have taken steps, whether large or small, to protect and advance the rule of law. Examples include lawyers who fight for justice for their clients, judges who follow the law even in the face of threats, and scholars who study our past and our present to find ways to improve our future. Individuals who work to ensure justice for all. These are the guardians of the rule of law who ensure the functioning democracy and protect human rights. The Lemkin Rule of Law Guardian Medal honors these everyday heroes, and it reminds us of the power of an individual to make a difference. Past recipients of the Lemkin Guardian of the Rule of Law Medal include Judge Esther Salas from the District of New Jersey, Professor Harold Koh from Yale Law School, our own esteemed Professor James Coleman from Duke Law School, and our inaugural recipient was Benjamin Ferez, who at the time of this award was the last living prosecutor for the Nuremberg trials. Today we are extremely honored to award the 2025 Raphael Lemkin Guardian of the Rule of Law Medal to 2 extremely distinguished scholars and public servants. Bob Bauer, who is the professor of practice and distinguished scholar in residence at New York University School of Law, and Jack Goldsmith, the learned hand professor of law at Harvard University, who are receiving this award in recognition of their collaborative and bipartisan efforts to study and propose reforms to the United States presidency to safeguard democratic processes. Bob Bauer served as White House counsel to President Barack Obama from 2009 to 2011, and he was general counsel to Obama for America, the president's campaign organization, in 2008 and 2012. Professor Bauer served as co-chair of the Presidential Commission on Election Administration in 2013 and co-chair of the Presidential Commission on the Supreme Court of the United States in 2021. He was co-counsel to the New Hampshire Senate in the trial of David A. Brock, a former Chief Justice of New Hampshire, and counsel to the Democratic leader in the impeachment trial of President William Jefferson Clinton. Professor Bauer is the author of The Unraveling: Politics Without Ethics and Democracy in Crisis, and is co-author, along with Jack Goldsmith, of the 2020 book, After Trump, Reconstructing the Presidency, books on federal campaign finance, and numerous articles on law and politics for legal periodicals and numerous bipartisan reports on policy and legal reform. Jack Goldsmith served as Assistant Attorney General for the Office of Legal Counsel from October 2003 to July 2004 during the administration of George W. Bush, and is Special Counsel to the General Counsel of the United States Department of Defense from September 2002 until June of 2003. He is internationally recognized as a leading expert on presidential power, national security law, international law, and internet law. In addition to After Trump, co-authored with Professor Bauer, Professor Goldsmith is the author of In Hoffa's Shadow, A Stepfather, A Disappearance in Detroit, and My Search for the Truth, as well as other books and articles on topics related to presidential power, terrorism, national security, international law, and internet law. Before joining Harvard faculty in 2004, Professor Goldsmith taught at the University of Chicago and the University of Virginia Schools of Law. He clerked for United States Supreme Court Justice Anthony M. Kennedy and Judge J. Harvey Wilkinson, III of the United States Circuit Court of Appeals for the Fourth Circuit. He also clerked for George Aldrich, judge of the Iran U.S. Claims Tribunal. Together, Professors Bauer and Goldsmith have developed a significant body of work analyzing and advancing critical constitutional reform. They co-chaired an American Law Institute bipartisan working group that developed principles for election count reform, which helped inform the Electoral Count Reform and Presidential Transition Improvement Act of 2022. This legislation, which passed Congress with broad bipartisan support, clarified the role of Congress in counting electoral votes and strengthening safeguards for the peaceful transfer of power. More recently, they co-chaired another ALI working group that produced principles for Insurrection Act reform, addressing concerns about potential abuse of presidential powers, emergency powers. And they co-produced a newsletter on Substack called Executive Functions, which aims to provide informed assessments on executive branch actions in legal, political, and historical context. It's instructive that in the introduction for their newsletter they write, "We have our opinions, and we do not always agree. We will do our best to provide accurate and fair-minded analysis, to separate analysis from opinion, and to acknowledge mistakes." Through their impressive body of work, Professors Bauer and Goldsmith demonstrate the power of principled, collaborative approaches to complex constitutional questions and provide inspiration for us who may not always agree, but who share the commitment to truth, fairness, and strengthening our country. Professors Bauer and Goldsmith, please join me here so I can hand you and award you the 2025 Lemkin Rule of Law Guardian Medal. Now I'd like to turn things over to our own Dean Kerry Abrams, the James B. Duke and Benjamin N. Duke Dean of the School of Law and a distinguished professor of law, who will lead our conversation today. Dean Abrams.
Thank you so much, Judge Grimm, and welcome and congratulations to both of you. I would like to start by asking you about the origins of your partnership together. You came from different backgrounds, different parties. As we heard Judge Grimm say, Professor Bauer, you were counsel to President Obama, and Professor Goldsmith was in the Office of Legal Counsel for President Bush. So what made you decide to reach across the aisle and form this partnership?
You want to start? The short version is that when Bob when Bob left the White House counsel's office, he was reflecting upon his time there, and he interviewed other people who had served in the office, including people of different views. I had actually criticized Bob while he was in office. I didn't know Bob at the time. I criticized the decision he made. He came to Harvard. We had a conversation. I went to a class of his at NYU. We started exchanging ideas, and then we were originally thought we should do something together because we had different perspectives, but we also agreed about a lot of things, and we thought it might be useful to try to have a collaborative project. We were originally going to write a book about the White House counsel's office. There's no great book on that, and we ended up, I guess it was sometime in 2019, thinking that we should really try to think through the problems with the presidency that we learned from the first Trump administration, and that led to the collaboration that led to after Trump. So, and it was we knew that we had these common perspectives, common experiences, some foundational differences. Turned out we agreed on a lot of things, and it's just been a very, very fruitful collaboration.
Anything to add?
No, that's exactly right. And I would add even the article for which I interviewed Jack in the first instance was one in which he graciously provided both a meeting where we could discuss it and extensive notes and comments on the draft. And it was also one in which, and this is not atypical of the collaboration, we agreed on a lot and disagreed on other things as set out in the article. So in that sense too, it's kind of illustrative of, or an example of the kind of collaboration we have with both a lot of agreement and then necessarily points of disagreement, or predictably points of disagreement.
So I'm curious about the two presidencies that you had front row seats to. When you started those roles, did you have ideas about executive power that shifted based on what you saw? And if so, were there similarities between what you observed in those roles, or differences, or both?
You know, as you asked the question, something occurs to me for the first time that I think was a bit of a pivot point in the way I thought about the presidency, which is that my relationship to President Obama was forged when he was elected to the Senate and then progressed through his presidential campaigns. And so when you represent somebody in a presidential campaign, you know, there's a tie there it's quite significant. You're continually rooting for success and trying to aid in every way that you can the success. But then when you get to the White House, you have to completely adjust the way you think about these things, because you're not there in a capacity as a personal or a political lawyer, and I've been both to President Obama. You have an institutional role. And yet everything about the White House pushes, how would I put it? It's a personalized presidency in many respects, and everybody in the White House on the senior staff is wearing the team jersey. And you have to learn when it is appropriate for you to show your team colors and when it's important for you to take them off. And so that has been, in thinking about the presidency, I thought about the importance of making sure that the jersey comes off at critical points.
I came to the Office of Legal Counsel after a year in the Defense Department with still pretty academic views of executive power. And I was there for only 10 months in the Office of Legal Counsel, but it was a very trying and difficult time. There was a lot of stuff, unusual stuff going on. It was kind of a couple of years after 9/11. And I would say the main lesson I learned, and this is perhaps not very insightful, is, I came to appreciate the need for a powerful executive, but I really came to appreciate the dangers of the executive branch, especially when it acts in secret, especially when it acts in a time of fear. So that was my main takeaway, and I've been trying to understand that ever since. President Obama was a lawyer, a trained lawyer, and he had views on the law. And my sense was that there was, and by the way, presidents are allowed to organize their executive branches to get legal advice basically however they want. And there are several models for how this works. And my sense was that the Obama administration's legal vetting process was more White House centered. Bob was a powerful White House counsel. The president was a lawyer. President Bush's White House was White House centered in a different way, but the Office of Legal Counsel had, I think, a somewhat more traditional role of providing kind of independent legal advice. I guess that happened too in the Obama administration, but it was different. How the president organizes executive branch lawyering, who the players are, who the White House counsel is, who the Attorney General, it really informs the way legal advice works in these administrations, and they differ from administration to administration. The current one is organized quite differently from either of ours.
So one thing that seems to have happened through both of these presidencies and in others is executive power has expanded. I hadn't thought until your answer to my previous question that some of that might be because of the people wearing the team jersey who surround the president, and maybe that's one part of it. But can you both talk a little bit about what you think some of the biggest expansions have been, and maybe why you think that kind of expansion has happened? I think it'll be easier to understand some of the reforms that you propose in your book if we understand the circumstance that we find ourselves in now.
Sure. I mean, the history of presidential power is long and complicated. But in a way, it's very simple. Article 2 of the Constitution vests the president and only the president with the executive power and creates an unstructured office. And from the very beginning, from the Washington administration, presidents have exercised those powers aggressively and unilaterally. And there's been a generic, and in most contexts, Congress has gone along with this, and there's been a generic rise in executive power, mostly for the first 150 years in foreign affairs and war making, and in the last 100 or so years in the domestic front as well. This has happened because as the world grew more complicated, as domestic and foreign affairs grew more complicated, Congress delegated more and more power to the president garnered more power to himself, and there's just been a long-term generic rise. So that's one chunk of it. Then we had this reckoning after Watergate, and Vietnam and the Church Committee. And there was a rethink of the presidency and an effort to kind of ground it in a new set of laws and norms, which is what Bob and I wrote about. That process regulated this supercharged imperial presidency, as Schlesinger called it, pretty effectively for a long time. But that was running its course and basically failed in the first Trump administration and is failing badly now. Basically, the presidency has gotten very strong because all of the incentives are for that to happen. The Congress has delegated power to it, and the constraints that people thought were necessary to keep it in check have basically diminished.
I would add only that I agree with all of that. I want to make a sort of political cultural point, which is we can't look past the expectations in our political culture of the presidency. It is a powerful office because, in many respects, I'm not sure what respect to accept from that statement. The public expects it to be a powerful office, expects things from the presidency, sometimes superhuman performance from the presidents. And they get credit for often things they actually haven't accomplished, and then sometimes don't get credit for what they have accomplished. But one way or the other, whether it's the economy, national security, crime, the cohesiveness of society, presidents are called upon to act in all of those roles. There's a wonderful book on this topic by a scholar at the Cato Institute, a libertarian tax exempt in Washington, D.C., named Jim Healy, and it's called The Cult of the Presidency. It's about all these expectations that built up about the presidency. So presidents come into office, both making extraordinary claims about what they can accomplish against a background of extraordinary expectations that they should accomplish them. And I think that's something that, as a body politic, we all have to, I think, come to terms with. And then presidents, therefore, under these pressures, take on more and more power. Sometimes they relish having it, for sure. And oftentimes that power becomes instrumentally significant to them in being able to produce the results that they are being held accountable for. And one thing I just want to mention, since we've talked about different roles of lawyers, is what happened to the White House counsel's office. There was no White House counsel until the Roosevelt administration. And then the White House counsel who was chosen at the time was really responsible for policy and speech writing for the most part. And it ended up developing into a law firm of sorts, but the original conception of the White House counsel that Roosevelt had was met with strong objection from the Attorney General at the time, who said, but I'm the president's lawyer. But that president's lawyer wasn't close enough, wasn't reliable enough, wasn't wearing the team jersey to the extent that Roosevelt, who was, by the way, notoriously suspicious of lawyers anyway, had looked for. It didn't become an office like it is today for a while, but now it's an institution, and it's an extremely powerful one that has soaked up, and we see that taking extraordinary forms at the moment, soaked up a lot of the responsibility for the legal affairs of the executive office of the president. What has happened now, I should drop a footnote, is now the power is going back to DOJ to some extent, but that is because presidents are not worried about appointing their own lawyers to DOJ who happen to have strong personal ties, past professional associations.
So you've made a couple references to the current administration, yes. And I'm wondering if you could compare the two administrations you were a part of to the current, for what you can see without being a part of the current administration, in terms of where some of this work is being divided and what the roles, say, of OLC, of the President's Council, et cetera, are playing.
So this is an extraordinary administration in terms of how it's organized legal decision making, quite different from any administration in American history, including Trump 1.0. And it starts with an undoubtedly true proposition that every president since Washington has embraced, which is that the President of the United States, because he has the executive power and because of the duty to take care to faithfully execute the law, holds the power to make legal interpretations for the entire executive branch in a way that's binding on the executive branch. That has been the formal position of the executive branch for 250 years. Most presidents, every president, including the first President Trump, delegates those powers and seeks various shades and types of independent legal advice to subject, in the rarest of cases, to presidential override. And so you have different types of administrations that organize that differently, but basically you have lawyers spread throughout the administration, including especially in the Justice Department, who are, with the idea that they're trying to help the president, are making good faith efforts to interpret the law independent of just helping the president. So this administration has organized itself, and it has not been shy about making this clear. There are directives to this effect. The Attorney General has made this clear. When the president makes clear what he wants to do, everybody has to get in line, including the lawyers. Occasionally, the Solicitor General is a partial exception. We can maybe talk about that later. Occasionally, they will seek the views of the Justice Department, but it's basically to understand litigation risk and not to really understand what the legal constraints are. They have basically taken this idea that the president determines the law, and they have made it an ironclad rule throughout the executive branch with loyalty requirements, firing through anyone who gets out of line and the like. What this means, to make a long story short, is one of the very important checks on executive branch power, underappreciated, has always been lawyers inside the administration. You know, you tend to see the OLC opinions that say, yes, you can do this, and that are controversial. You don't see the dozens and dozens and dozens of pieces of OLC advice or White House counsel advice that says you can't do this, you shouldn't do this, you have to do it this way. That is not happening in this administration. And if there have been a lot of examples of people being fired for not marching in line with what the president wants. And that is quite a change. We've never seen that before.
Just one more example, because I completely agree with that description of how extraordinary the current situation is and how it differs from the prior two administrations. Just to be clear, I mentioned earlier, there was once this great concern about the White House counsel as an institutional force within the White House under the president's control, one floor above the Oval Office, who is going to be soaking up the responsibility for the legal affairs of the presidency and drawing it away from the Department of Justice. And now, that issue, which was lively debated for a long period of time, has become somewhat passé. And it's become passé because, in a way that other presidents would not have, and we can discuss why they would not have, the president has chosen to take, essentially, in addition to the steps that Jack described of enforcing loyalty, he has staffed virtually all of the key positions, and including recently the cases that he cares about, with members of his former personal legal team. Attorney General, Deputy Attorney General, Principal Deputy Attorney General, Solicitor General. Very recently, as you know, he fired the U.S. Attorney, or forced the resignation of the U.S. Attorney in Virginia, who had not complied with his wishes in bringing an indictment against former FBI Director James Comey. But the personalization of the legal corps is hard to emphasize, really exceptional. It used to be there were criticisms of presidents for appointing White House counsels who were too close to them. I was an example because I had done political and personal work for the president before he became president. And there were criticisms of attorney general appointments on same grounds. Too close, and then the attorney generals, when sitting before the Senate and awaiting confirmation, would be pressed on whether or not their prior association with the president would in any way compromise them as attorney generals in office, and they would deny it. They'd say, no, that was then, and this is now. A good example being William French Smith, Ronald Reagan's first attorney general, who had been briefly a lawyer for Ronald Reagan in a personal capacity, and he was quick to say, I recognize there could be a conflict, but I don't think it is in this instance a conflict overall. But if there's any circumstance in which somehow my former personal representation would conflict with my government representation, I'll recuse myself. That's not the gospel in the current administration.
Mm-hmm. You mentioned earlier that it was unusual to have, or maybe not unusual, but it was a fact that you were counsel to a lawyer.
Yes.
How did that impact how President Obama thought about using counsel? Like, did it make him more likely to argue with you, more likely to spot issues and bring them to you, and almost asked to be constrained? What was that like?
I would say the good news was that you could have conversations or write memoranda to the president about issues that you wouldn't necessarily expect a non-lawyer president to be familiar with, like standards of review in cases of constitutional adjudication, and he would understand it and take a great interest in it, and he did understand the role of lawyers. Of course, the bad news was he didn't take everything I said at face value. And so I did, in fact, have conversations in which the president raised the presidential eyebrow skyward because he wasn't certain that the argument that I was presenting, it wouldn't necessarily even mean that it would have imposed a constraint on him, but he might, like a good lawyer would, show me where he disagreed or press me to better make the case for the position that I was urging.
What about the current administration's use of the Solicitor General's office and of litigators in general? Because you alluded to the firing of a U.S. attorney for not bringing a case. Do you want to say more about that, Jack?
Sure. There's a huge disjunction here that I think is not sufficiently appreciated. The Justice Department and the White House have been insistent on complete control of Justice Department attorneys and U.S. attorneys out in the U.S. attorneys' offices in carrying out the president's will before the lower courts. And these are, of course, the courts that the administration has been attacking and threatening and being disrespectful towards in really unprecedented ways. But then the Solicitor General is the person in the Justice Department, an assistant attorney general who argues the government's cases before the Supreme Court and also regulates government appeals in the federal courts. The Solicitor General has an important relationship before the Supreme Court, and the Supreme Court depends on the Solicitor General and relies on the Solicitor General, and the Solicitor General's office has always had special duties towards the court of candor and the like. And that relationship, it wasn't clear to me how that was going to work, but that relationship has been quite different. The Solicitor General has at times made very forward-leaning arguments before the court, but it has also showed the court extraordinary deference in a number of situations. And it's also quite clear that the Solicitor General, John Sauer, has had a lot of influence in the White House in deciding we shouldn't press this case. This is not going to be a good case to press. And even though you're upset about what the lower courts did, we shouldn't go forward there. This one we can do. Sauer, I think, has the most independent influence of anyone, it seems, more so than the Attorney General, who is not really interested in this type of relationship, apparently. And so that relationship has been quite different, and I think that explains partially the success that the Trump administration has had before the court at this point, because Sauer has been extremely strategic in deciding which cases to take to the Supreme Court on interim orders and which cases not to. So that's the lay of the land as I see it.
So you wrote your book after Trump, in a year that was after Trump, or a time that looked like it was after Trump. We're not now after Trump. Can you talk about some of the reforms that you set forth in that book? And then looking back, it's 4 years later now, which ones do you think are the most urgent today? Are there reforms that you proposed that we don't need anymore? Like what? Just reflect a little bit on what's happened in the last 4 years and how it affects the proposals in your book.
I don't look back at the array of reforms, and we didn't write it with the expectation, by the way, that all of these reforms would suddenly enter into serious conversation and head toward implementation. We recognize reform is hard. And what we saw after the Nixon-Watergate episode is quite an unusual experience with an extended period of institutional reform, as we saw at that time. But I think it's fair to say, and maybe, I don't know that Jack and I have matched up our rankings, but my views change from time to time as circumstances dictate. I suppose I'd start by saying, and we worked on this together under the American Law Institute working group that we did on insurrection reform, and we worked with the Congress on other emergency reform, as other people who were called upon to give advice did. I would certainly put emergency reform very much at the top. I put Insurrection Act reform, which is a form of emergencies reform, of course, very much at the top. National Emergencies Act, as well as Insurrection Act. I think there are things that can be done and that we hope to work together on the pardon power, for all sorts of reasons that we can discuss, which I think is a critical part of that even more complicated question of what do we do if, in fact, it becomes the norm that presidents exercise the kind of direct personal control that this president is exercising over the Department of Justice, and all the norms to the contrary have kind of faded on the shelf. How do we rethink that? So there's some that we propose that I think we could still proceed with, and others that I think would have to be developed in response to what we have learned over the last couple of years.
I'll just add a few points to that. I agree about emergency powers reform and Insurrection Act reform, and we and a lot of other people were warning during the Biden administration that these authorities for the president to use the military in the domestic sphere were massively broad, with very few, practically no checks, judicial or congressional, and that they were very dangerous in the hands of a president who wanted to use them. And that reform, the Insurrection Act reform and the National Guard reform, basically got nowhere. And we're living with that now, and the president has the current president can do lots of things with the military in the domestic sphere lawfully. And this has been known for a long time, and nothing happened about it. Some of the reforms that we proposed are just, a lot of the reforms we proposed had to do with White House Justice Department relations. And I think those have just been overtaken by events. I mean, most of them were kind of norm-based reforms that Trump's not interested in, and they're going to be very hard to implement. The only thing I'll add that we put front and center on the table that would have been a very useful reform to have had was a variety of statutory fixes and executive branch, but especially statutory fixes regarding conflict of interest, corruption, self-dealing, presidential businesses, all of the things that are happening now, which are kind of open forms of corruption with the president and his family benefiting personally off of public office. These were foreseeable problems. They were fixes for these problems. I would say that this is an important fix going forward. I think we're only seeing the beginnings of how deep and bad this problem is. So I would add those to the list.
I forgot to add one near and dear to my heart, and we wrote about it, and we actually developed a specific proposal for legislative language to implement the reform, and that is presidential power to deploy nuclear weapons.
And what was the language?
Well, the language, we actually printed the language, we printed the proposed language, again, just to get the conversation going in the back of the book in an appendix where some of our other proposals were summarized, and in some cases we also proposed language. But right now, I don't want to overstate the case, and I don't have precisely how we put it in front of me. Jack, you might know better than I do, but there are just no meaningful controls on the president's ability to utilize nuclear weaponry. So if you consider, for example, the claims that the president's currently making under Article 2 authority to just like blow boats out of the water off of Venezuela on the grounds that he has that authority to control drug trafficking, what happens if the steps that he feels he needs to take in the exercise of that authority include the fateful step of activating nuclear weaponry? And I think the controls are, it's not, we can get into a conversation about whether there are no controls at all, but they're not robust.
So one theme I'm hearing is that we have had informal norms that have created ways for presidents to be held accountable, and those norms have fallen apart, and you are turning to statutory solutions potentially to actually have some teeth behind what used to be mostly governed through norms. I'm wondering how much of the erosion of norms has to do with the erosion of disapproval by the public mattering. Like, I'm thinking back to the Clinton presidency and the Starr report, and I was in law school when that was all going on, and it was all extremely shocking. And the idea that someone could survive that kind of public disparagement of his character, and someone who had behaved in that way could then continue in the office, seemed surprising to people. How much of the power of the social norms around the office had to do with thinking that there would be some sort of backlash if someone was behaving in a way that went beyond the bounds of what social propriety expected?
A lot. And there's been a kind of long-term or medium-term generic diminution of norms in Washington around a lot of issues. And it was happening with the presidency before Trump got there. But, and I'll just say that I did not appreciate, I've been studying the presidency for decades, but until the first Trump presidency, I hadn't appreciated how pervasively it was really a self-constrained, norm-based president and not laws that was doing a lot, if not most of the work, including in the Nixon administration, but certainly for the 50 years after that. And so this gets me to Trump's superpower is his shamelessness, of his utter indifference to the consequences of doing something indecorous or norm-breaking or even law-breaking, but especially all the norm-breaking right up to that. And it turns out that a president who doesn't care about that, and as you say, there was this diminishment in the bite of norms in the decades before Trump. A president that doesn't care about that, and especially whose base doesn't seem to care about that, is massively empowered, because most of the constraints on the presidency are just that. Even I'm learning so much of, it's too complicated to get into, but even it turns out the appropriations power of the Congress and the way that those relationships had worked over the past 50 years, I had thought about it as being strictly law governed, but it turns out it's largely norm governed, kind of in the interstices of the laws, and the Trump administration is just blowing through that. So if you don't care about those norms, and if your support doesn't care about those norms, then the presidency is massively empowered.
Yeah, I agree with all that, and I would just add, it's hard for these norms to stand the pressures of intense political polarization. Because if each side, this has been said over and over again, but if each side regards every political conflict on a major issue to be existential, absolutely unsurvivable if the other side wins, unsurvivable if you don't win, then who cares about a norm? We're not talking about law. Some of these norms, like the president not having control of the Department of Justice, are shaky norms, and presidents have pressed against those norms. I mean, Richard Nixon appointed his former campaign manager to be the Attorney General of the United States. There's always been an attempt on presidents to push in the direction of more control rather than less control of the executive branch. But if the norm that is being invoked is going to paralyze presidential action when presidential action is considered to be urgent, very hard to say to your supporters, I can't deliver that because there's a long-standing norm. And that norm, in turn, is associated with institutions that, by definition, your supporters consider to be corrupt and failing.
That's a central part of this. I mean, that I didn't mention, is that the institutions are failing, and therefore the norms associated with, or are perceived to be failing, and are. And so the norms in connection with those institutions just aren't valued. That's where we are.
So we've talked a lot about the presidency in relation to the Attorney General, in relation to lawyers. Could we talk a little bit about the presidency in relation to the judiciary and Congress, and the current interactions between the executive branch, Congress, and the judiciary, what you see happening, what might change?
Separation of powers.
So I've already mentioned the Trump program against the lower courts, which I view as despicable, and in terms of personal attacks, personal threats, massive serial disrespect of the judge's orders. I think the district court judges made a lot of mistakes, as judges sometimes do, and there's an appellate process to fix that. So I'm not saying everything that happened against the Trump administration was justified, but those attacks are hugely corrosive and threatening, and have been terrible, and they're ongoing. And as I said, also, the relationship with the Supreme Court has been quite different. I'll just add that I want to defend the Supreme Court, and I'm sure this won't be popular, but I am not one who thinks that the court's performance on its interim orders docket, the emergency docket this year, where the Trump administration has won about 90% of the cases brought to it, I do not believe that the court has in any way performed dishonorably. I think it's still very, very early. As I said, the Solicitor, I think there's not a single, this is maybe a reflection of my views, but there's not a single decision that they've made that has been, to me, obviously wrong. The Solicitor General has been very careful at bringing the most egregious lower court decisions, combined with the ones they care about, combined with the ones that it knows the court is inclined to agree with, to the court, which explains the skew, in my opinion. And there are legitimate criticisms about the court on the interim orders docket about whether it should be writing more and explaining more, but there are serious downsides to that as well. It's a very tricky and complicated process. And I'll just say that we're still very much in the early innings of this presidency and this court's encounter with this presidency. There are going to be a lot of merits decisions this term. And so one can criticize the court because one disagrees with the court's jurisprudence. Bob and I have a little bit of a disagreement about, I'm not even sure it's a disagreement about how much the court should be adjusting its jurisprudential views about, say, the unitary executive to deal with the Frankenstein version of the unitary executive. But on the whole, I think it's too early to judge the court, and based on what they've done thus far, I think they've generally done what I would view as a good job. Also, we have this threatening president, and the court itself is in a precarious position, and it's extracted concessions from the president. It's pushed back on the president at times and important times, and the executive branch has paid attention to that. So I just think, just like it was too early to judge the court for its early interim orders in the first Trump administration on where we ended up on the court and presidential power. I think it's too early to judge right now.
You want to keep the separation of powers now that you've heard the answer?
He disagrees too much with me on this.
Yeah, well, let me just say something very briefly about the courts. I don't disagree that it's too early to judge. I think, and I'll make this just 2 bullet points. One, I think the court is been struggling with, I can't say every justice, but I think there's a majority on the court that is struggling with the difference between unitary executive doctrine in its most abstractly formulated form that they have been attracted to for a long time, and what they're seeing in Trump 2.0, which is where that could lead, that I don't think even people who are critical of Trump 1.0 expected. And so the court is facing a challenge that everybody is facing with a presidency that is this unprecedented in so many respects. But there's going to be coming up soon a real test on a couple of cases, more than a couple of cases, about sort of how to best judge the court. The second thing I'd say on the question that Jack raised, what do you do about the surrounding environment that the courts, how the court brings into its adjudication what it understands to be what the administration itself really intends to do with the unitary executive powers that it's seeking. And I don't think it has any choice but take into account what's taking place. And I think you see that if you have a chance to read it. You see that reflected in part, not in whole, in part in the district court decision in Oregon, in which the judge enjoined the federalization of the Oregon National Guard, and last night also the federalization of the California National Guard for deployment to Oregon. Congress, because I detoured us. On Congress, years ago, a famous article, my colleague Rick Pildes and Darrell Levinson wrote a book about the separation of parties, not powers, and that was an important insight, and I think what we see is...
You should explain it a little more.
Yeah, the basic idea being that Congress does not currently operate under a clear-cut bipartisan sort of institutional sense of its responsibilities under the Congress. It is an extremely partisan institution. And this has been, by the way, this breakdown in an institutional sense of the Congress transcended in so many respects bipartisanship is quite a long time in developing. It's just reached a crisis point, whereas a practical matter, the party in power sees it as obligated to be essentially the most reliable ally a powerful president could possibly have, as opposed to looking for opportunities or necessities of defending Congress's institutional equities. And this is a disaster. I mean, it's a complete, total disaster. And both parties, you know, it's gotten progressively worse. You can certainly argue Republicans do, Democrats haven't behaved any better. They're just as partisan. We can go through that whole history of congressional conflict. But one way or the other, you know, we have seen it time and again, and it's just, particularly in an environment of retribution, an environment in which those in the party who stand up to the president and decide they're going to object to a course of action or cast a vote that he disfavors are going to get run out of the party. They're going to have the choice of either facing a primary campaign heavily funded to defeat them, and not to mention all sorts of calumny thrown their way, but they may have to resign in order to take the stand that they want to take, which is what you saw recently with Tom Tillis in this state, right? And there is no, it's such a complicated topic, and I don't pretend to understand all of it, but there's no easy answer to this. But it is definitely a critical part of what we're seeing in this superpowered presidency that has developed and is being taken to such exceptional lengths right now.
Can I just add one quick thing? Sure. I know we're getting short on time. I just want to underscore what Bob said, because in my view, the essential problem with the presidency today is the collapse of Congress as a check on the presidency. That is at the top of the list of problems. The framers, James Madison, assumed what Bob just said is no longer the case, which is that the members of Congress would protect their institutional interest vis-a-vis the executive branch. And what Bob just described is a breakdown of that and an elevation of party loyalty over institutional self-preservation. And if I were going to put at the top of the list what's led to an overcharged, under-accountable presidency, it's this.
So hopefully some of the students in the room are going to be members of Congress, lawyers to the president, in the Department of Justice, in many of these spaces, judges in the future. What does the future of bipartisanship look like to you in this, given that we're in this moment right now where each side views the other as an existential threat? What kind of advice would you give as two people who have come together and even gotten an award today for your bipartisanship to people that are hoping to try to solve some of these problems going forward?
I'm going to let, you're the political lawyer.
I'm the political lawyer.
Yeah.
I don't, and I think you're asking sort of what's the path forward to some kind of bipartisanship. I'm not cheerful about our prospects, but I haven't given up all hope. I do some work that involves my traveling around the country, and it's not as if you don't see this polarization evident in states or localities. Somehow that if you get away from Washington, D.C., it's a lower order problem. It definitely infects politics throughout the country. But having said that, I do see, and I just want to stress two critical points speaking politically here, I do see that there are some, how would I call them, red lines, psychological red lines, that I hope we don't see starting to fade. One is, there is a widespread belief that presidents need to comply with court orders, and that the Supreme Court rules and rules directly in a way that commands presidential compliance, the president should comply. There are widespread beliefs that elections have to be conducted fairly. By the way, I'm not arguing that's true on the part of political actors. They may really disagree with that, although they pretend not to. But that, for example, again, this state being an example recently, you don't change the rules after an election has been conducted in order to reverse a result that you didn't like. There's some of those red lines I see absolutely mirrored in conversations I have with Republicans on some of the projects that I'm involved with them on, where they may have voted for Trump twice, they may be very polarized in their attitude toward Democrats and what they view as democratic misgovernment, but they haven't surrendered those principles. They haven't walked away from them. What worries me, I'll just close with this, is this environment, and both sides are pointing fingers at the other, of intense retributive response, whether it's tit-for-tat revenge or cancellation across the broad spectrum of ridding yourself of the trouble of other people speaking their minds, is going to cause the people of goodwill to be silent because of fear, for their livelihoods, for their safety. That is one of the gravest threats that we face. I see it all the time in my work. I wish I could end on a more cheerful note.
I don't have any great prescriptions here. The structural influences on polarization at the political level are so strong and growing. I think that we should all, everyone in this room, this is a message that I try to tell, and maybe it's obvious, we should all try to understand the people on the other side better. There's just not enough real effort at empathy to really put yourself in the shoes of, I do not think that Trump supporters are evil. I understand where they're coming from, and I spent a lot of time trying to understand the views of both sides, and it's really a helpful thing. And so I just urge us all to not be kind of knee-jerk in our dismissal of the views of the other side as stupid or degenerate or fascist or whatever, because I think that there's a reason why Donald Trump was elected twice in 3 years, and so I just think that, and there's a reason why there's so much opposition to Trump, and I just think that we, on an individual basis, need to try to break through that, and that's not a structural solution.
We have a couple of minutes left. Are there questions that you've been dying to ask? Yes, Max.
Hi, thanks so much for coming. This is in my very limited 1L understanding, the efforts after Vietnam and Nixon to curtail presidential powers left a lot to be desired. Like, I think about the War Powers Resolution and these efforts to curtail presidential war-making, but we're now in a period of expanded presidential war-making power. What tips would you give to reformers now, learning from that past era of reform, to try and make reforms that stick?
War powers is just a hard one. You picked probably the least successful of the 15 important reforms. It was a badly drafted statute in an area where the president is hard to constrain, frankly, and where Congress, if it really wanted to constrain the president, needs to do so through the military that it gives them. When you give the president a 2 million person military that's spread around the world, the war powers, a Swiss cheese war powers resolution isn't going to stop that. Most of the reforms were highly consequential and successful for a while, not all of them. It's hard to draw, but they faded over time because the political pressures to defeat them were so intense, both from the presidential perspective and from the political perspective. We went through every one of those reforms and suggested ways to improve them. I would just say, again, that controlling presidential war powers is the most difficult task. But there's a lot that can be done to translate what used to be governed by norms into being governed by law that can be enforceable, even against a recalcitrant president. And a lot of the post-Watergate reforms kind of went part the way with the law and relied a lot on norms. And I think it's now clear, absent a kind of sea change reform of the executive branch at the constitutional level, it's now clear that these constraints need to be much tighter and they need to be embodied in a statute. But the War Powers Resolution is hopeless.
Yeah, I would just add to this, I think, and Jack has written about this, and I think this is true, it may be impossible to, and this means the reform hill is even harder to climb, it may be impossible to accomplish some of the most critical reforms without thinking about constitutional reform. Not going to happen in my lifetime, I doubt, short of some Silicon Valley-inspired medical miracle. But it seems to me that there's some of what we would want to see happen by statute is just not going to get us where we need to go. We may need to be rethinking these institutions because some of them are just not going to operate the way they were originally designed under current pressures and with the collapse of norms. And the only other point I'm going to make is this. There was a remarkable bipartisan quality to the reform effort in the post-Watergate era, not across all of the statutory enactments, but across many of them. But there are some enactments that crashed, like campaign finance reform at the federal level is a dead letter. And part of the problem is because it wasn't designed on a bipartisan base. It didn't have enough bipartisan support. And it's the reason why the attempt to salvage that reform in 2002, the so-called McCain-Feingold law, bipartisan campaign, whatever it was called, Reform Act, it failed because there was so much Republican opposition to it and a commitment from the very first day to undermine it. So to the extent that you want long-lasting reform, you're going to have to try to find a way to buy in the people who strongly disagree with you at the beginning.
Which happened miraculously once during the Biden administration with the Electoral Count Reform Act. But I agree, you need that kind of bipartisan buy-in, and that's hard to get these days.
Well, I've learned so much from both of you. Thank you. Congratulations.
Thank you very much.
And let's thank Jack Goldsmith and Bob Bauer for being with us today.